going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. All right, I've got a good one. Now, here's a little advice for you. Not legal advice, but if the police are looking for your son or anyone that you're close to, and you know that they're looking for him, don't hide evidence because that's exactly what this dad did. And he finds out the hard way what happens when you do that. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Michigan versus Paul John Nugent, file number 2470102FH, time and date set for sentencing. Mr. Nugent is present, represented by attorney Michelle Arstead. People are represented by prosecuting attorney Timothy J. Witkowski. By way of history, on May 6th of this year, the defendant had pled no contest to tampering with evidence. Ms. Karen Everlands prepared the pre-sentence report. It's dated June 11th of this year. Ms. Siv, have you and your client had the opportunity to review the pre-sentence?
Yes, we have, Your Honor.
Are there any additions, deletions, corrections, or objections to the report other than guidelines?
No, Your Honor.
You agree with that, sir?
Yes, sir.
Mr. Witkowski, any objections to the report as well as guidelines?
No, Your Honor.
Ms. Siv, any objection to the scoring of the guidelines?
No, Your Honor.
Thank you. What would you like to say on behalf of your client before the court?
I did have a chance to go over the recommendation with Mr. Nugent, and I would ask the court to consider a short period of probation for Mr. Nugent. At the time, probation is not recommended, and 30 days in jail with revocation is one of the crimes of cause. Mr. Nugent he runs his own business. He has about 70 lawns that he cares for. He did have a list of his clients that I did see this morning. He also has been with Sugar Factory for going on the 11th year this year, and orientation for that is on August 7th and 8th. And we'll hear back from them around the 15th of the month, and that will go until April. So he does have that appointment coming up. And also, Mr. Nugent, he does acknowledge his prior criminal history, while raised minimal. He only has one prior felony conviction on his record, according to the report. And so I would ask for the court to just consider a period of probation and hold the jail time in advance to Mr. Nugent and the circumstances here. And other than that, adopt the recommendation to arrest time.
Does your client wish to address the court in light of the no contest?
He does.
Mr. Nugent, go ahead.
Your Honor, today my son was arrested. I was working at the factory and I stopped over after 11 on second shift. And the door was burst in ajar and the heat was blaring. My son called me from the jail. They recorded phone calls. He asked me to look for his phone to look up the number of a woman that would possibly move into the house. So she could keep an eye on things. He was broken into twice in January after that. There was no crime scene tape. I had no way of knowing this was evidence. He had 3 charges against him: stalking, reckless driving, and domestic violence. And I assumed that they had all the evidence for those things. I took the phone home. I looked up a message from this woman, and I sent her a message saying, please call me, John's in jail. I'd like you to move into the house. And the next day, I had no intention of breaking the law. I had no way of knowing this was evidence. Phone calls revealed that I just looked up this message. The next day, I went there in the morning, and to fix the door lock, it is cold and cold coming in. They were searching the house at this time, and the deputy came up to me and he asked me, well, did you take anything from the house? And I said, no. Next question out of his mouth was, well, do you have his phone? And I said, yes. And here it is. I gave it to him. As far as I know, that's what I did wrong. I first said no. 4 seconds later, I said, yes, here's the phone. I did not intend to tamper with any evidence. I did not know it was evidence. And I hope you have leniency. I run my own business, my lawn care business, you know, all that.
Why would you enter a plea then if you feel you did nothing wrong?
It's a great question, Judge. Great question. And I think just about every judge out there would ask the exact same question. He doesn't think he did anything wrong. Now, what he just said, it doesn't really sound like he did anything wrong. And if it happened exactly that way, and he didn't do anything to the phone, but what he just said, he probably wouldn't be charged. But we're going to get to hear from the prosecutor here in a moment, and let's see if you guys might change your mind. All right, let's keep going.
I was advised by my wife and my lawyer saying, well, Paul, you got to take this plea, otherwise they throw all these other charges on you. And the juries are fickle, and they might say, well, you're innocent of this one, guilty of this one. And I didn't want to go on to this trial, but my wife and everyone suggested that I make a plea agreement.
Anything else? Mr. Rakowski, anything to add?
Mr. Nugent comes before you with one prior felony, 3 prior misdemeanors. It's fairly clear from the investigation that Mr. Nugent knew that his son had a warrant for his arrest. But then when they get the phone and they look at the phone, the defendant's texting his son, don't go outside. Please call me. So, I mean, he knows what's going on. For him to say that he had no idea what was going on there, he did. I agree with Ms. Siv, but for different reasons that the recommendation is not appropriate. 0 to 9 is the guideline range, and they've recommended 30 days, which we don't agree with. We think there should be more jail time. If the court's not going to give probation, there should be more jail time because of the circumstances. His son had a warrant for his arrest for a period of time. They've been looking for him. They go to the house. He doesn't know anything about it, yet he texts his son, don't go outside, after the police were sitting out on the house and see that his son went into the house. So, in light of those things, Your Honor, we ask that the court consider somewhere in the area of 90 days.
All right, that's not what I remember. This happened last week, so I'm sorry for the misinformation there. But so it looked like he's taken a plea deal of tampering with evidence, but what really happened is he was charged with some kind of interfering, and he took a plea deal for tampering with evidence, I guess. That's what I'm assuming. I don't know. It's still an interesting case though. All right, let's keep going.
Any reply?
Your Honor, just that I reviewed the options with my client, and it was his decision.
Oh, sure. No, I understand that, but how do you respond to more jail time rather than what's being recommended?
I would ask that the court still consider the same amount of time that was recommended, but just help in advance.
Well, the court had the opportunity to review the pre-sentence report, and if I'm not mistaken, the factual basis came from the police report that the court reviewed as well. And it was a matter of taking the phone that had evidence on it. It was a matter of what appeared to be the court of communication between the defendant and his son relative to police being outside of the residence. And that's how I understand it to be. And considering that, and considering the defendant's history in this case, it will be the sentence of this court that regarding probation recommendation of just straight probation in this case, the court understands why it's being asked for, but the court is not going to grant it. The court is going to follow the recommendation, though. 30 days in the county jail, credit for 1 day previously served. He can serve that on the weekends if he wishes to. Crime victims assessment of $130 will be ordered. Court cost of $200 payable at the rate of $25 a month. A fine of $200 will be ordered, payable at the rate of $25 a month. I'm waiving attorney fees. DNA testing fee of $60 will be ordered. $68 in state costs will be ordered as well. I have no objection to work release. I have no objection to PA 511 status. However, under the circumstances and the fact that there was a prior felony, the court is adopting the recommendation in this case. My duty to inform the defendant he has right to seek leave to appeal. If he's financially unable to provide counsel of his own choice, the court will assign counsel form of public expense. He's to initial the receipt questionnaire form requesting the assignment of counsel. That must be executed under oath and filed with the court within 42 days. Oh, yes. Does the defendant wish to serve weekends or straight jail time? Because if it is weekends, there is no work release.
The weekends, Your Honor.
Weekends? What time do you get off work?
Let's see, later this month, I'll be working day shifts for the first week. And then I'll go on second shifts following that. 3 o'clock on day shift.
You're done at 3?
On the day shift for the first week or 8 days. After that, second shift is 3 to 11, and trying to think, second shift, typically Friday and Saturday are my days off. Second shift.
So this weekend would be day shift, correct?
I don't,
August 2nd, 3rd, 4th? You're not sure?
I'm not sure, they haven't called me back yet.
Okay. But if it is day shift, you're off.
All right, they're just trying to schedule his jail time around his job. All right, yep. Again, the judge kind of said what I thought after I told you guys the wrong thing. So hopefully you all forgive me and enjoyed the video anyways. But that's all I got. There's about another minute of them trying to schedule his jail time. That's pretty much it for the case. You guys all have a great rest of your day, and I will see you later. Until next time, bye.
You said 1? 3?
Yeah, second, third.
And what town do you work in?
Seaboard.
Seaboard. Okay. You are to report this Friday at 4 p.m.
Yes, sir.
This Friday, and then if you go to afternoon shifts, then Lieutenant, I'm assuming that's something you can work out with the defendant.
Yes, as long as he brings a schedule in.
Okay. Monday, you release. What time do you start work on Monday morning? Usually
7 in the morning when it occurs.
6 a.m. on Monday. You'd be released.
Yes, sir.
All right. Good luck to you, Mr. Nugent.
Thank you.
Thank you. Officer.